who's at Coy Middle School. I grew up in Beaufort, North Carolina, but I've been in Ohio since 1994. I lived in Beaver Creek the last 12 years. I have 3 degrees. I have a BA in history from Campbell University. I have a MA in philosophy from the University of Toledo, which makes me really weird. And then on top of that, I got a Juris Doctorate from the Dayton Flyer School. And my wife tells me she's so glad I finally got the JD, because at least I have 1 degree that's not pre-unemployment. She's the woman who graduated from the Fishers School of Business in Miami. Decision Science, I believe, was her statistical business degree. I've been practicing law since '08. It's a second career for me. I was an assistant prosecuting attorney for 5 years with Clinton County, so I did get to put people in prison for a living. Since 2011, I've had Culpepper Law, where I focus on doing estate planning for families. I particularly have a passion for young families because they've done nothing, and 70% of them have never even picked guardians. And believe it or not, they have the most valuable asset and the most vulnerable asset of their kids. And like I said, when I'm not practicing law, I love to spend time with my favorite assets, my wife and 3 children. And yes, I've been trying to convince my son of the value of making his bed and picking up his clothes. He just doesn't get it. He just thinks, I want to get back in bed. Why do I have to make it? So anyway, a little bit about me. I have 2 questions for you guys. How many of you in the last year at your club have had an estate planning attorney talk?
No.
All right, because I didn't want to come in and say stuff that somebody had been there before. So one of the things I've been taught about public speaking, always ask who's been before and what have you guys heard. Okay, well then I have 5 different potential talks that I could give to your club, and I think all of them are very relevant based upon what I'm hearing from my clients as I talk to people. So the first one would be 5 reasons to never give an outright inheritance to your children and what to do instead. 5 reasons to never give an outright, some of you may say never give an inheritance, period, an outright inheritance to your children and what to do instead. Estate planning attorneys who know what they're talking about will tell you there's absolutely no legal good reason to give your money outright to your kids. And I got you people thinking already. You see, you want to have me come. There are 5 reasons for that, and I would love to come and get you guys thinking on that one. Another one I could give is how to keep the state from taking your house if you have to go into a nursing home. I find this is clearly an issue that a lot of people are concerned about, with 70% of us sadly having to go needing some type of long-term care, and about 1/3 of that number having to go into some type of care facility. It is clearly a concern, and as an estate planning attorney, I do Medicaid planning. I know how to help avoid that. It's not a comfortable topic to talk about, but when you look at a semi-private room in a long-term care facility in Dayton is $78,000 this year, an Alzheimer's unit would probably be 90 plus. It is clearly a concern that people have. Another thing, another talk I could give is six situations when a trust makes sense, and I spell it C-E-N-T-S because it will save you money. I've had people come in who've been to other attorneys, and I have talked to them, and I've been shocked that the attorneys never mentioned to them situations when a trust could make sense. And it's a lot more practical for a lot more people. They're just completely unaware, and I'm not sure why the estate planning field of attorneys are not educating their clients on that. Another topic could be 3 tips on picking an estate planning attorney. Hint, hint, we're not all the same. Believe it or not, this may shock you. There are different philosophies that attorneys have in approaching estate planning. I think some of them are, if I was knowing what I know now, I would not want that business approach. I have much more of a relational approach. When I explain it to my clients, they get it, they like it, they would prefer to come to someone like me. And then the last one, 4 reasons probate is estate planning failure. 4 reasons probate is estate planning failure. I consider it estate planning failure. You can completely avoid it, and there are 4 good reasons why you want to do that. Again, I'm kind of teasing you because I'm not telling you, but as I love to have me come in and I'll explain. So let me give you, in the remaining time I have, just one point of one of the talks. three tips on picking an estate planning attorney. Hint, we're not all the same. Here's one of the things I would advise you. There are estate planning attorneys who charge by the hour. I think that's a bad business practice. I think they ought to charge you a one-time flat fee. Here's 2 reasons. Number one, you know how much you're going to pay. With an hourly rate, the problem is you only know the rate. You ultimately don't know what you're going to pay. And at $250, $300 an hour, that scares a lot of people. Okay, so I would recommend that for that reason. The second reason is, to me, hourly fees, and I understand in litigation, it's hard to get away from it as an attorney, but to me, it attacks the very root of law, which is a relationship you want to have with your attorney. So Tony, how much do you want to talk to me when I'm charging you $4.16 a minute?
A minute.
Exactly.
As little as possible.
However, if you know you're paying me a flat fee and you can talk to me as much as you want, different story.
Right.
You're going to call me up. I've seen people who've gotten in trouble because they're so scared of paying the attorney fees instead of calling their attorney, which could actually save them more money. And so I love that practice, and that's what we do. So let me tell you a little story to just even emphasize this. I have a friend, Gray, who is a business associate. His mother got to a point where they had to get a guardianship over her because she was not able to make good healthcare decisions for herself. Typically didn't know an attorney. He went to an attorney in his networking group and asked him, can you and your firm do this? Yes, okay. So about 3 weeks later, he goes back to the networking group. He has a quick question to ask the attorney. And so they have a quick chat. Thinks nothing of it. Guess what happens in 3 weeks?
You got a bill.
You got a bill. Let's just say his emotions were not fond of this particular Dayton law firm. And he said, it gets worse. He said, he billed me for 15 minutes. And then he goes, first of all, he said, I know we only talked for 2 or 3. And then he goes, I bet somewhere in that contract I didn't read is a clause which says, if you talk to any of our attorneys, and there are firms who have this, it's a minimum of 15 minutes. And it gets worse. It gets worse. It was a $5,800 bill, he told me. The parents had this farmland, and they were trying to sell some farmland. And as you know, selling farmland is not easy. There are not many buyers to pay off a lot of different bills. Their parents were older. The firm did not want to work with them. They hired another attorney and sued the family and got a judgment against them for $5,800. So I tell you that to say 3 things. Number one, if I'm your estate planning attorney, you can talk to me anywhere you see me during the estate planning process. I will not charge you more. You will not get a bill from me in the mail, and that's the kind of attorney you want. Number 2, I do payment plans. I have clients who need estate planning, but for cash. They have assets, but it's not liquid. I work with people, and I don't even charge interest because I want you to do the estate planning you need to do. And the last thing is, I have a policy, I don't sue my clients. There are plenty of attorneys who will. Yeah. So, well, unless there's other further questions, I'll close with what Forrest Gump says. You know, that's all I got to say about that.
You still have time.
Tom?
Yes.
What's a good number to reach you at?
We just moved over to Paragon. I'm in Centerville.
Okay.
But I will give everybody cards, and if you want to, I have several things I've written. This is particularly, there's a little bit of some of the differences. This is particularly focused on parents with minor kids and a little bit of what we talked about in the kids protection planning. I am the only attorney licensed with Family Wealth Institute in the state of Ohio, Indiana, Kentucky, Michigan, doing kids protection planning. Because I have people from Kentucky. Well, I've got clients now from Massachusetts, Missouri, Chicago, because I'm the only attorney in the Midwest who is doing a particular type of advanced guardianship planning, and I have people coming to me because they cannot find another attorney to do that.
You also do wills?
Do you mean up to age 18 or?
Correct. Correct. Because up to 18, they have to have a guardian.
I have kids 40.
Do they need a guardian?
There are some that do.
Some of mine do.
One of the 5 reasons I will tell you to not give your money outright to your kids, and I hear this from clients. They've got kids that they know they can't give money to. they will either do things, they will blow it, or it will ruin them. There's people, my father always told me, there are people who cannot stand prosperity. And if you have me in, I'll give the talk. I'll tell you stories of people who inherit money at 18, 21, finished college at 30, and who have never really worked a job. I mean, you have to be careful with what you have to do with your children.
Tom, do you do wills?
Yeah, I do wills, trusts, I do gun trusts, that's a different story. I do Medicaid planning. If you own a business, we're gearing up to help you do business succession planning. I'm part of a group, forming a group. We're still nascent, but it's called the Business Transition Association. So I'm doing a lot more, but right now I'm focusing just on estate planning.
Thank you.
So if someone comes in, I'm talking about that individual or family comes in to see you, and you have that discussion, you may say, well, you need a living will, you need a regular will, you need a trust, and you may need to have 3 or 4 or 5 things.
You're going to need all that, I would.
Yeah, and then you're going to say, okay, so now to be fair, here's what it will cost you for me to do all those things. So
correct.
Okay.
You get 3 things from me. You get documents, you get my time, and you get ongoing services. One of the failures of one of the models of estate planning I dislike is they don't help you. Once you've created the documents, you're only halfway. The second part is you have to title your assets to avoid probate. For example, we'll create an asset spreadsheet of everything you have, and I will give you individual instructions for every piece of property you own to figure out how to avoid probate. A lot of attorneys don't want to do that because if you go through probate, they make a whole lot more money. There was a farmer in Clinton County, cash poor, land rich, 2.4 million. Legal fees were $70,000 in probate. Again, for at least 4 reasons why you want to avoid probate. To me, I would make a whole lot more money. Yes.
So even though you have a will, that doesn't necessarily...
That gets you into probate. You will not avoid it. It only works if you go through probate.
I did not know that. Yeah.
You're right. There's a lot. There is a lot. Not only that the public doesn't know, there's a lot the public is misinformed about.
So I thought it was avoided.
Now you see why I'm a relational educational attorney, because you're learning. I spend 4 to 6 hours with you. I had clients in last week, and their attorney through the whole process probably spent 45 minutes with me. Never told them anything about if it went to trust, nothing about Medicaid planning, nothing. Just created documents.
I have a question. I do have a trust, and I've delayed putting my house in the trust because I delayed putting my house in the trust. And can I just go and get a deed, type it up myself, and take it down to the courthouse or whatever it is?
Yeah, if you know how to do it,
Kind of,
I mean, you would have to transfer. You would have to transfer it if you get it right. Now remember, LegalZoom, the #1 promoter of self-done estate planning, and I got a snapshot of their website where they say that 80% of the people they find misfill out their own forms. And what does LegalZoom recommend? Go talk to one of their professionals, i.e. an attorney. How ironic. But yeah, no, if you can do it, yeah, that would move your house.
Yeah.
And there's something else you could do as well.
File my trust. Haven't done that.
No, but I'm
Call
not giving you all
Tom.
my secrets. You have to come see me.
Call my attorney.
Otherwise,